I'm going to talk about the Summary Appeal Court. The first thing to say is that the Summary Appeal Court is separate from the Court Martial Appeal Court. The Summary Appeal Court is a court to which a serviceman can appeal following conviction and/or sentence by their commanding officer at summary hearing. By comparison, the Court Martial Appeal Court is an appeal court that hears appeals from the Court Martial, not from summary hearing. So that said, I'm going to talk briefly today about the Summary Appeal Court. So a serviceman who has been dealt with at summary hearing and who remains dissatisfied by the outcome of the summary hearing, whether that's as a result of conviction or sentence or both, has the unfettered right to appeal the entire matter, if they wish, to the Summary Appeal Court. The time scale is normally expected to be within 14 days of sentence at summary hearing. So within the 14 days of sentence, the serviceman is expected to lodge an appeal to the Summary Appeal Court. That also means that they can insist that any sentence passed by the summary hearing commanding officer is deferred until those 14 days have elapsed in order for them to decide whether or not to take the matter to Summary Appeal Court. Another important factor to remember at Summary Appeal Court is that the Summary Appeal Court cannot increase the sentence that has been awarded by the commanding officer at summary hearing and cannot impose a legal costs order. The advantage of summary hearing is that it is quick, but the disadvantage is that the commanding officer will not be legally qualified. So if a serviceman takes a matter to summary hearing and is dissatisfied with the outcome, they have the unfettered right, the automatic right, if they so wish, within 14 days to lodge an appeal at the Summary Appeal Court. Now, the Summary Appeal Court is made up of a judge advocate and two lay members, the lay members being officers, warrant officers, as you would find at a court martial, but just two of them and the judge advocate. And in that way, it is roughly similar to appealing from a magistrate's court to a Crown Court in the civilian system. So the Summary Appeal Court can consider the whole matter afresh, consider whether or not the facts are proved, and then if the facts are proved, and only if the facts are proved, of course, we consider the sentence, but they cannot give a harsher sentence than the commanding officer already gave at summary hearing.